Good day and welcome to this week's episode of Strictly Legal on WESN Content Capital. I am your host, Rondell Donawa, and once again I'm happy to bring the law and you. And of course this is our final episode for the year, so I'm very excited, and this is why I have my Christmas little Santa tie and my very loud tie today. So we are celebrating the season, and the reason for the season, of course, it has been a tremendous year, of course, with numerous guests, and I am pleased to once again bring a topic to you which is very, very important. It's called alternative dispute resolution. Various methods. What is alternative dispute resolution? Of course, my guest today is Jason K. Charles, attorney at law. He's a mediator and he is an IT consultant. Just a bit about Jason. He is also certified by the Mediation Board of Trinidad and Tobago as a mediator in civil, non-family matters, and he's one of the neutrals appointed in Trinidad and Tobago by the World Intellectual Property Organization to their panel of mediators. So prior to joining the legal fraternity, his profession for more than a decade was in the field of information technology, where he amassed considerable knowledge of computer hardware, software, networking, etc. It's interesting to note, though, that actually, before I wanted to be an attorney, I actually wanted to be a computer engineer. So I think it is good to note that, and the roles have been reversed. So without further ado, I welcome Jason, who is joining us via Zoom. Good morning, sir.
Good morning, Rondell, to you and your viewers. Happy to be here and happy to be able to speak on this important topic of EDR.
And we are grateful for you to be here joining us, and we love your background. I must say, I did tell you that before before we came on. And so just, and it's interesting. I mean, I know I was telling you, we were speaking before the show started, but why law? You were in IT before.
Yeah, so, I mean, it's strange, but I mean, a number of disputes, conflict is a part of life. And I mean, you see disputes in IT all the time. Somebody had a licensing agreement, for example, and that particular agreement didn't go off as planned. Somebody wrote a piece of software for somebody and the software didn't execute as planned, and then you would end up in court, etc. So, I mean, I've seen disputes even from the IT side of things. As I was telling you before, it's strange because I did law at A-levels, sort of made a commitment to myself that I would never venture into law again. I mean, I was successful at it and then found myself right back in the law because of IT. So, you know, it's sort of, I guess, over the pandemic sort of accelerated the need for IT and law. You would have seen that a lot of the court hearings have moved to virtual platforms, electronic filing. So I don't think the two are not inextricably linked.
Yeah, of course, and it's also important, particularly persons who are not IT friendly at all. I mean, you will be lost, as you know, with the virtual hearings, virtual filings, and everything is now virtual. So I think with an IT background, you are ahead of the game, I must say. So let's talk about mediation as an alternative, one of the methods of alternative dispute resolution. Tell the audience, what exactly is mediation?
Well, let me give a general definition of alternative dispute resolution first, and then let me give you some of the examples of what alternative dispute resolution offers, and then perhaps we could go into mediation.
Indeed.
So really, what alternative dispute resolution is mechanisms or systems that offer an alternative to what is the norm in most jurisdictions, which of course would be court or litigation. So you have many different examples of EDR, some of which would be like early neutral evaluation, expert determination, conciliation, mediation, and arbitration. By far, mediation and arbitration tend to be the most popular, and you sometimes get a blend of them. So you might get med-arb or arb-med, which is, you know, to essentially have mediation before arbitration, and then or arbitration and then mediation afterwards. Most practitioners tend to lean towards these two as their main things, but there are instances where you may want an early neutral evaluation or expert determination before moving into a different forum.
And okay, so you've explained in terms of alternative dispute resolution, but is it important versus, or is it preferred versus going to court directly or settling your dispute in the courts?
Certainly for me, and you know, and it's funny you mentioned that because I came across a quote when I started doing EDR actually at law school, and I think it's applicable. So Supreme Court Justice Sandra Day O'Connor is often credited with this statement. And she makes the statement that the courts of this country, she's of course speaking about the USA, but I think it's applicable to most jurisdictions, should not be the place where resolutions of disputes begin. They should be the places where the disputes end after alternative methods of resolving disputes have been considered and tried. So I think that should be the starting point. Unfortunately, in many jurisdictions, it's not.
And this is why also is important, as you know, to at least when you are presenting a claim or when you go to a lawyer, the first thing you write is a pre-action protocol letter, and I think the purpose of that is to try and settle without having to go to court.
Of course, and I mean the spirit of our CPR, actually our civil proceeding rules, and for most jurisdictions that have civil proceeding rules, the spirit of it is in fact to try to have early settlement, to try to negotiate, to try to not have the matter go to court unnecessarily. And I mean, if you read it in its spirit, that's essentially what it is. So I don't think that EDR is not, out of sync with what the CPR intends. Some CPR, so for example, Jamaica has gone a little bit further, and Jamaica has actually implemented via their CPR, via Part 74, what is referred to as automatic referral to mediation for most of their civil matters. So some have gone that particular direction. I'm not sure what would eventually happen with our jurisdiction, Trinidad, that is. So we had pilot projects, if I'm not mistaken, one in 2010, one in 2013 of EDR, mediation in particular, and it was quite successful. We also have judicial settlement conferences that run in our court system.
Yes.
And I was extremely heartened to hear at the opening of the law term last year that the civil jurisdiction, which is, I believe, supposed to move to the waterfront, because the whole civil arm of the registry is supposed to move to there. I was extremely happy to hear the deputy court director indicate that they are going to encourage people to use alternative methods of dispute resolution. And she went further to say that mediation rules have been drafted and have been forwarded to the Rules Committee. So I suppose that sends the signal, the thinking of the judiciary moving forward.
And of course it's cost effective, because I mean some mediation or some alternative dispute resolution practices doesn't necessarily have to be with attorneys. Parties can actually meet and resolve the issue through a centralized mediator.
Of course. And I mean, what a mediator really does, because you did ask this question earlier, so I mean, let me bring a little context for the viewers. So mediation is not really adjudication. What the mediator would do is essentially he or she would facilitate dialogue between the parties, allow them to sort of move past those impasses they may have had, and to essentially brainstorm and come up with solutions. I think Professor William Ury says it best. He's attached to the Harvard Law School, and he wrote the book Getting to Yes. Mediation essentially has 3 steps. It allows you to essentially go to the balcony and sort of reflect. And once you're able to reflect, then you're in a position to essentially be creative. When you're creative, you can build the other side a golden bridge. And once you build that golden bridge, you can eventually try to work out solutions that will be beneficial to both parties. So essentially mediation will look at not necessarily, I mean, the merits are important, but it will look at what's right for the parties and essentially develop a solution that's best for them. Now, I'm sure you've heard the term win-win, but Professor William Ury, and I agree with him, goes a little bit further, and he speaks about 3 wins. So win-win-win, which essentially is sometimes you have 2 parties at the table, but there's a third party who's actually not at the table. So let's look at it from a business perspective. You have business A that provides a particular service. Business B is essentially saying, let's say, business A has infringed my service. But meanwhile, the customer, which is C, is not getting the service that they want from either A or B while the dispute is going on. So that person is not actually sitting at the table. Now, a couple of things could happen. Customer C can move on to a new provider while A and B continue to battle with this. Or customer C could essentially have no service and customer C's business can go down. So there's always a third stakeholder. So essentially what you're aiming for is win-win-win. Ultimately, and I tell parties this, when you have a mediation, if I'm acting as mediation advocate, not as a mediator, I would tell my clients this then. A 60% deal financially, and forgetting even the cost of the mediation itself, but a 60% deal for you, you may not get all that you want, might be more beneficial to you if you can get that in a 6-month period as opposed to a 3 to 5 year possibility of 100% win. Right. Because business has to go on.
That is an interesting concept, because some persons think, okay, I need to get 100%, right, of whatever I'm claiming. And then when you look at the length of times you take to get that, and then you have to pay cost, etc., it works out to 60%.
Precisely. Additionally, the added benefit as well to us that you might preserve a relationship with a supplier or provider. So the court may not necessarily provide that, but the mediation process would allow for you all to essentially appreciate each other's positions and interests and sort of had that dialogue that may allow you to see from the other person's vantage point, because essentially both persons might be standing on a table and one seeing a 6, one seeing a 9. The mediation process may allow the two parties to essentially be able to swap that table and be able to see the 6 and 9. They may not necessarily agree on everything, but at least they would have some understanding as to why I feel this way. And that allows for relationships to continue. In business, that's extremely important.
Indeed. And let's go to the other forms of alternative dispute resolution. I know we touched on mediation. And what are the other types of...
So there's arbitration. And arbitration tends to be a little bit more formal. So arbitration might be a little bit more like court. But again, there are benefits that you may not necessarily get from the court system. So the immediate one that comes to mind is that you have some choice, and this happens in mediation as well too, in that you can select your neutral. So the parties have a choice of selecting your neutral. So if you want a particular neutral with particular expertise, you're dealing with something like, let's say, a patent, and you want a particular neutral.
And this neutral is someone who is the arbitrator, someone who's sitting.
Who is the arbitrator? So arbitration panels may come as 3 or may come as 1, dependent on the type of arbitration, right? But you can select the neutral, and if you can select the neutral, then the neutral may have the expertise that you require to understand the particular nuances of your matter. So that's one advantage automatically of arbitration. Another one that comes to mind is that it tends to be final, so there's no appeal. So when you get a decision, very limited appeals, it tends to be binding, so you don't have it languishing in the court system and going up the road. You also have, and this is extremely important, especially in the world that we live in now where we have global presence, you have what you call the potential for cross-border enforcement and recognition via the New York Convention. So Trinidad, for example, is a signatory to the New York Convention. What happens is, dependent on the seat of arbitration you choose, that decision can be enforced in a foreign jurisdiction without much difficulty, and it can also be recognized there. There is something very similar being developed now for mediation. It is actually available. Unfortunately, Trinidad hasn't signed on for the Singapore Convention.
Right.
So that came into effect in 2019. Thus far, we have had 55 countries that have signed on, and we have 8 persons that have ratified as of this week. So what that would do for mediation is essentially the same thing that the New York Convention does for arbitration, which is allow that enforcement and recognition internationally, so that when somebody does something in a particular jurisdiction, they know, okay, listen, if I have to deal with this person in another country, I can pull this particular settlement or award that was given to me at the arbitration.
Mr. Charles, we have to take a break. We'll be right back after this and we'll discuss more. You're watching Strictly Legal.
Palace. Minutes from the capital city, an oasis of peace and tranquility await your arrival. Set in the midst of tropical flora and fauna, the palace abounds with scenic decks and modern-style rooms to mid-sized conference rooms and multiple reading nooks. Guests enjoy free Wi-Fi, 2 pools, an on-site restaurant, free parking, and call ahead for airport shuttle. Special wedding and birthday packages also available. Alicia's Palace, the refreshing escape you've been looking for.
Sometimes a little care starts the holiday cheer, a vision to bring unlimited smiles. Despite our distance in miles, shared sight of the reason we're together again for 'tis the season. It's Christmas at Ferreira Optical with a special 20% off transitions and iCNtt eyewear. Plus, get 10% off AccuView contact lenses. Enjoy this season with Ferreira Optical. Schedule your visit at ferreiraoptical.com or call us at 227-7000. Promotion ends December 30th. Conditions apply. Merry Christmas from Ferreira Optical.
Trinidad and Tobago, don't play with your life. Remember to follow all COVID-19 guidelines at NLCB Lottery Center.
COVID-19 is no game. Play it safe.
And we're back, and you're watching Strictly Legal on WESN Content Capital. We are speaking about alternative forms of different methods of alternative dispute resolution with Jason K. Charles, attorney at law. So before the break, Jason, we were speaking about arbitration. Now, let's deal with clauses in a contract or with respect to arbitration. Let's get more involved in that. What is exactly those types of clauses?
Right. So it's usually advisable when you're drafting contracts, if you happen to have a contract, before the conflict arises, to put in what we call clauses that would deal or address dispute resolution. So at least nobody at that stage is uncertain as to what the procedure would be. Usually what we do is we do escalation clauses. So we may have a clause that would say, for example, mediation followed by arbitration if the mediation wasn't successful. So you may have mediation, and the mediation is not to extend for more than, let's say, 30 days. And then if that is unsuccessful, then you move into arbitration. That is usually advisable, and it's generally best to use what we call tried and practiced clauses. Try not to be too specific, so you don't try, for example, to name the actual mediator or the arbitrator that you want to hear the matter, because then you may have difficulty if when the conflict arises, that person is unavailable or maybe no longer with us on planet Earth. So you tend to try to keep those clauses. So you may, for example, list an agency. You may say, for example, that you would like mediation followed by arbitration, and the mediator or arbitrator should come from, let's say, for example, the Dispute Resolution Center, which is the Chamber of Commerce's arm of mediation and arbitration. So you tend to try to be as general. It's best to use established clauses and not to try to be too specific.
Right, and basically in terms of the established clauses, what are those what are those examples?
So this is not necessarily a plug for WIPO, but I mean, you can get clauses from WIPO. So WIPO is one of the best examples I can think of.
And that is the World Intellectual Property Organization.
That's the World Intellectual Property Organization. I mean, you know, of course, theirs would be specific to intellectual property, although I think there's an option to filter and change to a general clause, but you actually have a clause generator on their website. So you can look at that. You can look at the Dispute Resolution Center. I think when they do their contracts, also has clauses built in as well to the general clauses. Most attorneys that practice in EDR should be able to advise you on it as well.
Now, in terms of, okay, someone has a dispute, they are going through now mediation or maybe conciliation. You could touch more over what is that. Tell us, what is the procedure? What do they do? How do they feel? What's the cost like?
Well, the cost would really be dependent on the mediator. So there are usually three ways that somebody ends up at the table for mediation or arbitration. So it might be in your contract, as we just discussed, and in which case the contract would direct who you need to go to. The courts, as I said, had a pilot project, and in Jamaica, for example, the courts would facilitate it. So in the case of mediation, the costs are split 50-50 between the parties. So that is actually one of the advantages as well too, that both parties pay equally. You may want a private mediation, and then you can reach out to a mediator, or you may want to reach out to a mediation agency, and we have several in Trinidad. So we have the Dispute Resolution Center that I mentioned previously. We have Dialogue Solutions. So sometimes the attorney may know somebody who's in practice as a mediator and may reach out to that person, and that mediator would set his fees. Sometimes you go to an agency, and the agency would essentially indicate what the fees are, but the fees generally are split 50-50 between the parties.
And does the person necessarily have to have a representative with them at a mediation session?
No, I mean, it really depends on the parties. I did one recently where both parties were unrepresented. You know, they both came there with their respective, I mean, they came with, so the principals of the companies came with persons from their organization, but they did not come with attorneys. It really would depend on how you as an individual think, you need to address the matter. Obviously, if one person comes with an attorney and the other person doesn't, then, they may need to reconsider. What the mediator would also do as well too is dependent on if they come to a settlement agreement. He may give the persons time to consult somebody that they trust, their own personal attorney, before that agreement is signed, just to make sure, they've gotten requisite legal advice.
And just to clarify the difference between the mediation and arbitration, is it that mediation is more of a relaxed setting and the mediator tries to come to some
mediation is a more informal setting, and in a nutshell, mediation, you get resolution. So the parties come up with their decision. The mediator does not make a decision. So the mediator essentially helps the parties reach a solution that they come up with, and that is reduced into writing, and that becomes a settlement agreement. If it's before the court, it may go back before the court for consent order, right? Arbitration, there's a binding decision. So the arbitrator actually makes a decision, and that decision is called an award, and that award becomes what the parties are bound by. So there is a distinct difference between the two. One leans more towards adjudication as our courts, and one leans towards more the parties forming their own agreement that they are comfortable with.
Now, I know we touched on the clauses previously. Now, let's say, for instance, an example, there's a contract, whatever contractual arrangement between two parties, and there's an arbitration clause in the contract. However, one party felt aggrieved and they decide to go directly to the High Court. Is that allowed, or can they go directly to the High Court for some sort of injunction?
The rules of contract would kick in at that point in time. The other side would essentially be able to raise there's nothing preventing the other party from taking it to High Court, but of course, then the other party has to respond, and the other party would respond that, listen, I have this contract that says X, Y, and Z. And of course, the judge would have to take that into consideration, and dependent on what is contained in the contract, the decision would be accordingly. And
then the judge can take it back to arbitration because that is part of the terms.
Yes. So, the courts themselves. So when the courts, for example, do quarter-next mediations, a matter is before the court, and the courts themselves essentially stay the matter for the matter to go towards mediation. So, it's not, the court. As I said, if you look at the spirit of our CPR, the intention is to try and have matters resolved, especially civil matters we're talking about here. And, the court tends to, exactly as the Deputy Court Executive Administrator said at the opening of the law term, to encourage stakeholders to collaborate and to use alternative dispute resolution methods. So if there's a contract, I think the court will be very hard-pressed to go the other direction.
And let's touch on, I know in your bio you are not a family mediator. Right. However, what is the difference? Why is it that one can be a mediator, but specifically non-family matters? How does that work?
Right. So our mediation act, actually is set up that particular way. So you have a certain amount of hours to cover if you want to be a certified mediator, and you have to be a certified mediator first before you can be a family mediator, and there are an additional set of hours to cover if you want to be a family mediator. Because of the sensitivity of family matters, etc., you tend to find that more training might be required. Some people, it's not necessarily that they don't have the training, but they think their particular expertise or their practice is not in family law, so they decide that they would remain in the civil arena. So it really depends on the individual and what they want to do. But family mediations are also very useful. At the family courts in Trinidad, we have a mediation arm that takes care of those matters.
And in terms of the family court, most times is it that the courts stand on matters so that parties can speak and mediate rather than the court making a decision for them?
So the court will usually ask the parties if they're willing to mediate, because mediation is really voluntary. It's informal. So, the parties have to be willing to mediate. You're bringing two persons just to sit down at a table. If they're not willing to discuss, is really not going to move the matter forward at all. So the court would generally ask, are the parties willing to mediate? And if they are, yes, they would stay the matter until the parties have had an opportunity to mediate, and the mediator has had an opportunity to also not only have that dialogue with the parties, but also to report to the court on whether or not he or she thinks mediation can happen and be successful.
And then this affects the children. It affects, I believe in family court is much more sensitive. So parties it's important that there be some sort of communication mechanism, or even in terms of co-parenting counseling as well. That can now bring some sort of
my earlier point about businesses having a continued relationship is definitely more applicable here, because if two parties have a child, or they have custody matter, or they have maintenance matter, or anything along that nature, the reality is they have a child together, they're tied to that child for life, and the relationship has to be preserved as best as possible. Yep. As they would say in the family court, and I'm sure most family practitioners, this would resonate with them, the children are paramount. the welfare of the child is paramount.
Now tell us, if someone wants to get in contact with a mediator, how do they go about that procedure?
Right. So I'm not sure what the courts would do, because I mentioned the courts, but previously, when we had the Court Annex program, the court may refer. That still happens in the family courts, where the judge would ask, but it's not happening in the civil courts. I mean, some judges were doing it and asking mediators to assist pro bono. I myself have done some for the court in that regard. But as it stands now, if somebody wants a mediation, one or two ways: you approach an agency, like the Dispute Resolution Center or Dialogue Solutions, for example, and that agency would have a roster of mediators, and they would put forward potential persons to deal with the matter, or they would have a roster of arbitrators similarly and put forward potential persons, and then the parties would select. Maybe they might put forward 3 names, and the parties with their bios, etc., and select. Additionally, if you don't want to go through an agency, and the 2 attorneys, for example, may know somebody who is a mediator, I've had that happen already, where they would approach the mediator and ask the mediator, listen, would you be willing to mediate on this matter first? And then it's done that way.
And
right?
where exactly?
Nothing prevents 2 individuals from doing that as well too.
Indeed. And where exactly is the mediation council for such persons who wish to seek some guidance?
Well, there's a mediation board of Trinidad and Tobago. There is no mediation council. The mediation board, if I'm not mistaken, is located on Upper Frederick Street.
That's just between, that's just
very
by
close
Edward
to where
Street,
the
yes.
old passport office would have been. Yeah, so I think they're in King's Court.
Yeah.
Right. I imagine you can call them, and your website, which hasn't been active recently, used to have a list of the mediation agencies that they approved. But I'm sure if you call them, they would provide some assistance in relation to directing parties as to what mediation agencies they've approved, etc.
Right. And do you belong to any mediation agency particularly?
So I am rostered. So besides WIPO, which I'm rostered with internationally, I am rostered with Dialogue Solutions, and I am rostered with the Dispute Resolution Center in Trinidad and Tobago.
Yeah. And I'm actually now pulling up in terms of the Dispute Resolution Center. That is disputeresolutioncenter.org.tt.
Right, so that's the Chamber of Commerce's arm. So they did the pilot projects for the court. So they did the 2 projects for the court when they did it in 2010 and 2013.
And of course, they can be contacted as well. Is it that they are at the ground floor chamber building, Columbus Circle,
Yes.
Westmoreland? Yeah. Right?
Yes.
So anyone who wants to contact even that particular institution is 632-4051 or 637-2642. All right, so Jason, tell us in terms of what is the need for mediation? Why is this so simply important?
So
including
the obvious advantage is that we would not have matters unnecessarily going to court. It would also be an advantage to the individuals, and that costs could be contained somewhat. Beyond that as well too, I think there are benefits to society, preservation of relationships. I've had mediations where the 2 parties started off at totally opposite ends, 2 brothers, for example, and at the end of it, they were friends again. We live in a very small society, and we have to realize that beyond just getting a judgment, persons have to coexist. Correct. And I think mediation provides that particular facility. The other thing I wanted to mention as well too, with respect to mediation, is that even if a mediation is perceived not successful, or you only have a partial agreement and not a full agreement, it allows the parties, even if they move into a different forum afterwards, for example, the High Court, to have a better understanding of the other side's issues and to have a better understanding even of their own issues. So it allows them to narrow the issues. And this is not necessarily, unhelpful, because it allows the parties, so they may essentially now plead differently, and not necessarily to their advantage, but they may say, listen, we had 3 issues, but having heard you, I realized that I really only have 1 issue. And we couldn't resolve that issue in mediation, so we take that to the High Court, but the other 2 issues have been resolved.
Yes, so you see, and you see, coexistence is important, communication is important. I mean, it makes no sense being someone's enemy for the rest of your life when you can at least settle things, move on. You don't necessarily have to be friends, but at least your conscience is clear, you can move forward.
Of course, and from even the perspective of businesses, as I said, it allows for that business continuity, it allows for the preservation of business relationships, it allows for parties to be able to coexist.
Correct. Mr. Charles, Jason, we are out of time, of course. So I want to thank you so much. And if you have anything to say to your viewers before we leave quickly.
Well, I mean, I just want to wish the whole of Trinidad and Tobago a blessed Christmas. Compliment to the season to you, compliment to the season to your viewers. Stay safe, everyone. Keep good.
Thank you so much, and thank you, and be safe, sir. Thank you very much.
All right, Rondell. Take care.
So, guys, it's a wrap once again. You were watching Mr. Jason K. Charles, certified mediator, attorney at law. This is the end of a season of Strictly Legal on WESN Content Capital. We started early in the year and we've had loads of guests, brilliant legal minds who have come together to give of their time and talent for you, the viewers. And once again, I'm grateful to WESN for giving us that platform to bring across Strictly Legal to you, simplifying the law and you. So once again, I'm wishing you a safe Christmas, guys. Remember, we are still in a pandemic. Please be safe, vaccinate if you can, right? So that we can come out of this soon. Of course, next year you will see another season of Strictly Legal with me, Rondell Donawa, attorney at law. It's been a pleasure. Have a safe 2021, Merry Christmas, and a happy 2022. Goodbye until next time. God bless.